Ladies and gents, welcome to this ITFA Seminar event. It's great to see so many of you here, and good to see that we have ITFA board members here as well. I think there's a few here now, and a few will be showing up later, apparently. And am I right in thinking, is this the first ITFA event of the year, or did someone else beat us to it? Oh, it's the first one, so there you go. Before I get into the rest of my intro, Chris would just like to come up and say a few words of introduction as well. Chris.
Thank you. Did I hear someone say I've got in the back there? Don't give me any ideas. It's nice to see so many people in here for an event in a pub and not having a drink just yet. But as you can see here, we have our conference in September in Budapest. We're going to have a great programme, so we'd love to see as many of you there as possible. But in the subject of London events, on the 20th of March, there's a FinTech Young Professionals event up the road in Bishopsgate, followed by a charity pub quiz, so we'd hope to see as many of you there as can make it. And as a bit of a sort of early taster, keeps chopping in and out, we're going to, in 2019, have our first ever Young Trade Financier of the Year award at the conference. So get thinking. Self-nomination, nomination of others, you'll see some criteria come out soon. So we're excited about that, and hopefully you guys are too. So with no further ado, Carl, over to you.
Thanks, Chris. For all you history buffs out there, just quickly a few words about the this place that we're in. This is the site of this building. Actually, was built in 1893. It has a long banking history. This was originally the office of a bank called Prescott's Bank, and the site was for a bank before that, which was named as Dimmesdale Fowler and Company. Then in 1903, Prescott's merged with Union of London and Smith's Bank, and in 1918 that was taken over by National Provincial Bank. That name might start to seem familiar for some of you, the more mature people in the room, and then eventually National Provincial Bank became part of NatWest Bank, National Westminster, in 1970. Today it's a pub, but much of the charm of the building and the old banking hall is still there for all to see. And I think this nice intimate venue up here is perfect for this kind of event. So I'm pleased that we managed to discover this and book this. So on to the seminar, which is in two pieces. First of all, we have Celia Gardner from Denton's, who will talk to us about topical issues in supplier finance. Then the second part is a panel discussion on the new BAFT MRPA. So with that, Celia, over to you.
If you could just get up the first slide. If you could just get my first one up. So, well, good afternoon, everyone. And first of all, a big thank you to ITFA for the invitation to come and speak to you today. I am most flattered by the invitation, and we'll be looking forward to exchanging a few insights with you over the next 45 minutes or so. Just before I go any further, you can all hear me well. I've been mic'd up and sort of draped in technology. I am actually a trained classical singer, so I ought to be able to project to the back without any of this stuff at all. But if the technology breaks down, then I will just project. Okay, well, what can I talk to you about? This was actually quite a difficult exercise to think of topic, because I'm surrounded here not by beginners but by some very experienced people in the market. So what I thought I would do is just look at some of the current issues that we're dealing with, primarily in the world of supply chain financing, which is a very active product that we're working on at the moment. But actually some of my issues are probably a bit more relevant for the supplier-led side of receivables financing. So it's a few current legal issues and observations that have come from the last year or so of practice. So, well, to start off with, supply chain financing, as I said, it's a very active product that we're dealing with at the moment. And before I go on to giving you some sort of interesting details, I'm going to give you just a little outline of the way it works, just in case there's anyone here who's not familiar with either the product or the jargon that we use. So the current sort of issues I'm going to be talking about, first of all, some that have actually come up in the documentation and negotiation of SCF documentation. And then there are a couple of issues that are very current because of recent either case law or changes to statute. And those are primarily to do with everybody's favourite issue in receivables financing, which is difficulties with the assignment of receivables, prohibitions on assignment, which is, of course, a perennial issue. Now, an outline of supply chain financing. It's very simple. What you have is a three-way position here. Is it better if I actually drop this and actually project a bit better? Yes, yes. It all goes back to, it's all about the breathing. So, there we go. What we will have is a three-cornered relationship. We have a buyer, we have a supplier, we have some kind of funding provider, as happens, of course, with all receivables financing. Now, this particular product is one that's very popular with supermarkets. The kind of buyer who is a good solid credit, attractive to bankers, will have a lot of small suppliers and all sorts of issues coming up on invoices. Lots of disputes, lots of problems, lots of relationships that need a bit of managing. And what we have got here is your buyer and your supplier looking at receivables financing for all the reasons why people want to do it. The buyer gets to extend payment terms. The supplier gets to be paid early. So everybody is happy, and that's a simple way of providing the benefits of the financing to both sides. Now, to go through in a little bit more detail, what we have got here is this process is facilitated through some kind of web-based platform. And the techie people here will understand how this works, and that is actually a very interesting area in its own right. But what we're looking at is a situation whereby buyers can actually approve particular invoices for discount, upload them onto a system. The suppliers will then have the option of discounting by selling them to our funding provider. Or perhaps this will just work as a kind of payment mechanism, and the supplier will simply be paid at the maturity of the invoice. The buyer will be getting an extended credit term. And of course, the nice thing for the buyers on this one is that, and I have actually been approached in the oil industry by buyers in this situation, there can be enormous working capital advantages to extending those terms to the extent that they can do what people horribly tell me is called monetizing their working capital, which basically means being able to on-sell whatever their stock is before they've actually paid for it. So that is a big advantage. Now, from the bank's position, what this is all about is the credit risk being driven by their assessment of the buyer. So an approved buyer, the bank's credit risk, and the bank obviously will be able to check out and credit check and so on. And the crucial point for the bank is that it is the buyer's undertaking to pay against which they're financing. And we spend a lot of time when looking at this documentation looking at the form of that undertaking to pay, how unconditional is it, and how it links with the assignment of the receivables, which you can do through the system in connection with the supplier. Now, if there is a problem with an invoice under this system, the idea of most supply chain financing is to make that the buyer's problem. So the buyer will unconditionally agree to pay the bank and sort out outside that system with the supplier if there's a problem. Not always, but that's the usual way of doing it. Now, an issue that we've been looking at recently that came up, I'm calling this the Carillion factor for no particular reason, except that one of our clients approached us just after the Carillion problem with an interesting question about their supply chain financing documents. And a question that was sufficiently interesting that we actually sat down with them and thought about whether they might like to update their documentation in light of this. And I think the nice way of putting this is the issue was basically, when does the music stop? Obviously, the Carillion, the buyer, who had once been regarded as very good credit, ceased rather dramatically to be the good credit. And the question was, there were some suppliers' invoices uploaded in the system. Was the bank committed to making the payments, which was obviously not going to be something they would recover from Carillion? Or were they in a position to say to the supplier, terribly sorry, we've never actually accepted this invoice and therefore we don't have an obligation to pay out? What the issue is, in legal terms, is at what point in the process of a supply chain financing was a contract entered into, which meant that the bank was legally obliged to pay out under its agreement with the supplier. So, I have the diagram here. The red is, of course, the insolvency. That's a good old-fashioned way of showing it. Basically, what we've got, can you see, or am I blocking the slide? What you've got is a series of agreements. You've got a series of communications. First of all, there will be an agreement with the buyer, there will be an agreement with the supplier, probably entered into very much at the same time, or not necessarily. Then we'll have a process of invoices being issued, invoices being approved by the buyer. Then we will have the bank working out its discount terms. Then we will have, at some point, the supplier indicating in some way that this is an invoice that they wish to sell. There will be an assignment of the invoice. There will be payment to the supplier. There will then be a payment by the buyer to the bank. Now, if at some point, and as you'll see over that process, we have an insolvency of the buyer, and I'm assuming it could happen at any time in the space that I have set out in that diagram, my question to you is, does the bank have to shell out or does it not? Now, don't answer that question because it's a trick question, as most of my questions are, as most lawyers' questions are, actually. The answer is, as always with law, it really depends. And that's basically why people like me have to spend so much time poring over very, very fine points of drafting. It depends. And we go back to some really, the law that anyone who's ever done a law course or been to law college will recognize this. It's the first thing we study in the contracts module. It is, how do we form a contract when we don't have a nice piece of paper here and a nice piece of paper here and two people will sit down and say, okay, well, we've brought together, we've got one contract here, we all sign it. You've got a series of communications which are now happening automatically, effectively, because it's all being done through the platform. And that is what is interesting to us, because what the law says, if you have some doubt as to when a contract is formed, they will say, well, essentially, there will be communications, and at some point the terms of the contract will be established, and at some point somebody has given a final assent to that, and that's the point where the binding contract is formed. And there are all sorts of questions in that chain. Is, when the bank gave its discount rate, was that the final moment at which the supplier accepts that, right, we've got a contract, the bank is now on the hook? Or are we going to say, well, actually, what happened was that the bank gave an indication of the rate, the supplier gave an indication they might be interested, and then the bank came back and said, okay, fine, we'll do this. Because if that's the point, then we formed the contract at a different point. And therefore, when the music stops, the music stopped and the bank's obligation to pay arose at a different point. So what's really coming out of this is there are no answers here. There's merely a question. And what interested me about this exercise was that much of the documentation that we've looked at that was floating around in this area was a little bit unclear as to the point at which this contract was formed, and therefore the implications for the suppliers and the bank in that insolvency. Now, so I would say SCF documentation is not always clear, and obviously that is something that providers of SCF facilities might like to think about. Now, just a final point thinking about that issue is that when discussing this with our client, there's two ways of looking at this, and naturally within the organisation you will get people looking at it at different angles. The one angle is the risk mitigation and the protecting the bank against its obligation maybe to pay out when the buyer is insolvent and therefore it can't recover. The other side, of course, is the reputational side. And one of my clients in discussing this with me said, well, ultimately, we don't want to be seen as the organisation, as the large financial organisation which left these poor little suppliers high and dry. We don't want to be in the court of the Daily Mail, and therefore we would actually be much happier just paying these out and not creating an argument over it. So obviously in business terms, those kind of issues are as important as the strict legal ones. But as I said, the interesting thing there was the slight ambiguity when we looked at the documentation as to which side it actually fell. Okay, so that was a good practical issue which would come up. Now, my second point, and really the rest of this presentation, is basically all about our favourite legal problem in receivables finance, which is restrictions on assignment in the contracts which give rise to receivables. Now, this is a perennial issue, partly because the law is quite difficult, and partly because opinions are very fierce and very, very divided on this point. There are whole areas of the market in which you will find people saying these restrictions on assignment, they are a huge problem for receivables financing. We must find a way of dealing with them. There is also a school of thought that restrictions on assignment are actually there for a purpose, and they are what these contracts are meant to do, and therefore they should be taken seriously. And I've heard both sides defended with great passion, and that's probably why this remains a perennial issue for lawyers. But over the last 12 months, we've had new legislation and some case law on the point, so I thought you might be interested if I just ran through where we've got to on these. Now, the law is set out in the attractively named case, Linden Gardens Trust against Lanester Sludge. So lawyers constantly go around talking about Lanester Sludge. This is not because we like clearing out ponds at the back of our gardens, but because it is a very important case in this area. And I've given you the full legal reference there in case you're interested, but basically this is the House of Lords, so at the time this was the highest court. And what they said is that if you have a contract which contains a prohibition or a restriction on assignment, usually it's no assignment without consent of the counterparty, but any form like that, then if the beneficiary of that contract assigns it without seeking the consent or without getting over that prohibition in some way, getting the prohibition lifted, then the assignment is void and the recipient actually gets nothing. Now that is the law, pretty clearly stated in Lanester Sludge, and that remains the legal authority, as we would put it, so that remains the law, basically. Now, as I said, a controversial case, and one that quite a lot of legal commentators have attacked. Now, the particular concern that this gives is the world probably of smaller enterprises who need to raise finance through factoring, because factoring involves full-blown assignments, it involves notified assignments, so it involves a situation whereby the assignee of the receivable is actually it's being notified to the debtor that this is your new counterparty. So prohibitions on assignment and restrictions on assignment are a huge problem to companies that are trying to raise finance through that route. Loads of contracts, all with slightly different terms, all saying slightly different things, all having to be reviewed. It's a problem. So the latest approach to dealing with this problem has come through this new legislation. And this is the Business Contract Terms Assignment of Receivables Regulations 2018. Snappy title, as regulations often get. Now, what has been done here is that this legislation, which effectively kicked off at the beginning of this year, it applies to transactions entered into on or after the 31st of December 2018. So we are, it's very much just coming into effect now. Now, basically what it states is that if you have the kind of contract to which the regulations apply, and I'll come on to what that is in a moment, then restrictions on assignment are disregarded. So that means that they have no effect. That means that our supplier can assign these receivables, raise its factoring finance without having to worry about these restrictions, and Lanesta sludge is effectively disapplied. So that's what the regulation states. Now, if we're looking at a supplier-led small business needing to raise factoring finance, these regulations are very useful and very helpful because they will be looking for an easy way to raise the finance that way. If you're looking at the buyer-led, so the supply chain finance, it is often actually the case that the buyers in that kind of arrangement want to have restrictions on assignment which are disapplied solely for the purpose of the supply chain finance program. So in the world where one is looking at supplier or buyer-led receivables financing, the position we're left in is that, again, it's controversial as to whether these regulations are what we want or not. Here's the tricky bit, which is working out whether these wretched regulations apply. And I don't know if any of you followed the history of this, but there was actually a rather embarrassing attempt to get an earlier version of the regulations onto the statute book, which was withdrawn because the legal commentary on it was so negative and about how unclear and how difficult it was for these to understand how the regulations worked and how they were far too wide in their application. So those regulations were withdrawn and we now have an improved version. But as you'll see, there are still some issues with clarity on that. Now, the first one is that they only apply where the supplier is a small or medium-sized enterprise. So this is very much not a blanket overruling of the law on restrictions. It's very much targeted. Now, the big problem with the definition is that, first of all, it's very complicated. And there are all sorts of exceptions. You are looking at accounting rules. You're looking at certain types of enterprise which are excluded. SPVs are excluded. Large enterprises are excluded. Foreign companies are excluded. But even more difficult is that the definition applies at the date the assignment is entered into, not the date that the contract is entered into, which gives rise to the receivable. So that means that you have this rather odd situation if you are contracting with an SME, is that you don't know when you're putting your contract in place whether these rules are going to apply or not at the time that the contract is formed. You actually have to look to the time of the assignment. So that's, shall we say, a little bit unhelpful, but there we are. Other exclusions, well, certain types of contract are excluded. So one always has to look quite carefully if the regulations are going to apply at the underlying business that it's covering. contracts that are nothing to do with a business or profession, contracts concerning interests in land, energy, certain types of derivatives, project finance, all sorts of contracts are actually excluded. So we actually have to look through, quite carefully look through what the regulations will say when you're assessing how effective this is going to be. Contracts that are not governed by English law are excluded unless the choice of another law was an obvious attempt to evade the regulations. So that's a fairly classic carve-out. If you are choosing, let's say we have two English companies entering into an agreement and they decide to choose to have their contract governed by Greek law, normally you'd say, well, that's okay if you really want, but if it's obviously to avoid something in English law, then that wouldn't be effective. The other thing just to watch out for with these regulations is that helpfully, though they're all about restrictions on assignment, they omit to define assignment. That is not as straightforward as it sounds, because we use the term assignment in all sorts of different ways. There are some very precise legal meanings that are given to it, but it's also used in a rather more general way to mean any kind of transfer. So it is best to assume that the restrictions on assignment refer to any kind of receivables transfer which is proprietary in nature. So in other words, different types of assignment, trusts, charges over, so if you're taking a security arrangement, you might take a load of receivables by way of a charge. It's best to assume that the regulations will cover all of that. But if you really want the regulations to apply, if you are taking an assignment and you really want the regulations to apply, then err on the side of caution and actually use the term assignment in your transfer document. So that's basically what I had to say on these regulations. So we are waiting to see how they're going to pan out. It's still very, very early days for those regulations, but as you'll see, there's quite a lot of question marks there. And it's not always going to be easy to see when they're going to apply to your transaction. Just to finish off, just to talk you through a recent case relating to restrictions on assignment. What's interesting about this case is really, first of all, that the legal common sense approach which was taken in an area where there were actually quite a lot of very complicated technical points that could have arisen. And secondly, Lady Justice Gloucester, as she now is, Liz Gloucester in the Court of Appeal, taking a good swipe at Leinster Sludge in her judgment, though she was not in a position to overrule it. Now, basically what happened in this case was that this is National Bank of Abu Dhabi, which is now the first Bank of Abu Dhabi, or first Abu Dhabi Bank, I think it's now called, and BP. And essentially what happened was that BP sold a receivable to FAB, and this was a receivable that was due from the Moroccan oil refining company, which is known as Samir. And the sale was carried out under the terms of a purchase letter, which I have, so when I look through this case, I know this purchase letter well. It's a BP relatively standard form. And basically what happened was that the underlying sale and purchase agreement between BP and Samir contained a prohibition on assignment without the consent of Samir. Now, you can guess what happened. The purchase letter contained standard provisions, including a repurchase provision if BP was in breach of warranties. So BP gave a set of warranties about itself and about the receivable, and the document provided that if these were false, then BP would actually have to buy that receivable back from FAB. And there was a warranty, and I've put the text up behind me because the text was considered to be quite significant in this case. But you'll see BP is giving some kind of warranty that it's not under contractual restriction from disposing of this receivable. Now, of course, you've guessed it, Samir went under. And so we now have a situation where very large sums of money have gone into a black hole, and FAB was looking for an opportunity really to protect itself here. So what they did was they took action against BP for breach of warranty on the grounds that this receivable was subject to a restriction on assignment, and BP had given this warranty. They sued for breach of warranty. They demanded their remedy of repurchase, which meant that they were basically repaid in full. And at the High Court, they won, essentially on that point about the breach of warranty. This went up to the Court of Appeal. Now, the Court of Appeal reversed that, and it held for BP. And what's interesting about this case is really, if you're interested in these things, just sort of going through. Essentially, there's an analysis of all the different ways that BP could effect the transfer of this receivable. And basically, there are loads of ways that we do it, both on a full proprietary basis and on a non-proprietary basis. So that is assignments, trusts of proceeds. These are all ways of BP actually transferring the asset that it holds in its claims against Samir to the bank. Then BP can say non-recourse, claim off Samir. The other way is non-proprietary, which is that basically there is an agreement between BP and FAB to put the parties economically in the same position. And you have funded participations, and you have guarantee arrangements, and you even have a reference to subrogation here, which are all ways that don't involve the transfer of property rights. But they all achieve the same economic effect. Now, what came out of this was, as I mentioned before, Lady Justice Gloucester took a good swipe at Lanester Sludge, didn't think it was right, but this is not anything that will change the law, because the House of Lords is a higher court, and she admitted that this was just a passing comment. She also held that BP was not in breach of its warranty. Now, partly this was on just the grounds of reading it, and certainly when I read that warranty, I didn't read it as saying the receivable is not subject to a restriction on assignment. It struck me that BP was saying we haven't entered into any agreement that would stop us from disposing of this receivable. In other words, they probably hadn't used it as security for something else. That was a discussion about construction, and that was a discussion on which BP was successful. But there was also the point that if you actually look at BP's standard letter, it does have a lot of provision in for saying if there is a restriction on assignment, these are the other ways we'll deal with this. We only assign if it's legally possible to assign. So both the construction of the warranty itself and the fact that the contract was drafted in that way protected BP very solidly on that. What she also looked at was all of these alternative methods, and the fact that the BP letter actually had a process in it for sort of saying, well, we'll try and do this, and if we can't do this, then we will do this. And she commented on most of these methods, most of which she thought were quite effective. There is one quite interesting one which relates to subrogation, which is probably for lawyers like ourselves the most difficult way of doing it, and the one on which there is probably least guidance in English law. This is actually something which is more common in European legal civil law systems, so the non-English law systems. But what she didn't do was pick out the magic bullet saying, because of this method, you're there. So we are left with our 8 or 9 ways of doing receivables transfers, and any of them might work. So that's basically what I had to say. So just to draw a few conclusions out of this. First of all, the reason that restrictions on assignment is a big emotional issue is because views are so passionate on both sides of the debate, and it's quite fun to have that debate sometimes, which is the better way of doing it. Secondly, if you want to do it, you can always transfer receivables in some way, even though you may have to use some of these creative methods that turned up in the BP case. And I was also interested that here is the Court of Appeal being incredibly pragmatic. So I think the message that we're left with that is, ultimately, all of the issues I've talked about today arose for the classic reason: the debtor under the receivable was insolvent. And that's what receivables financing is all about, protection against that situation. What is actually coming out is that there is a lot of activity going on and repositioning in the market as to how we're going to deal with the issues that come out of this, but that essentially receivables financing is a very practical and is a useful way of financing, which seems to be able to deal with these issues one way or other. So unless there's anything anyone wants to throw at me, I think that was basically all I had to say. Yes. Well, certain types of contract related to energy are completely taken out of the realms of those regulations. Now, the regulations aren't particularly clear about that, but they are anything in the energy market is basically subject to probably more specialist contractual structures. So yes, if you're dealing with contracts in the world of energy, you need to check against the regulations, because the regulations probably don't apply. So restrictions on assignment will be fully effective.
Celia, might
Yes.
be worth just pointing out again, you touched on it once,
Mm.
because a lot of us deal with international sales.
Yes.
So they just happen to have English law. And that's
Yes.
the implications of
Yes.
the UK, but those regs won't apply.
No.
We're talking about
Yes.
SMEs, yes. We're talking about domestic UK
Yes. Yes.
arrangements. So
Yes.
a lot of people in this room won't have to worry about this at all.
No.
because
No.
all the contracts you're dealing with are outside the UK.
That's right. This becomes relevant when you're dealing with things like the supply chain financing with the supermarkets and things like this, who may have a lot of small UK suppliers. But any of the international contracts, that is outside the realm of those receivables. Absolutely. Mm.
Celia,
Yes.
I think there are lenders out there that will actually say, well, assignments or restrictions on assignments, actually I don't care.
Yes.
In actual fact, I'm not even going to take an assignment.
Yes.
Because I've got that unconditional guarantee
Yes.
from the buyer.
From the buyer.
Is it
Yes.
too simplistic to
Well,
do it in that way, or is it?
It's interesting
is that
because
relevant?
I've seen SCF structured that way, and every now and then I ask myself, is there any reason why you wouldn't want to do that? Because actually a very simple, clear undertaking from the buyer, which effectively makes the whole thing really just into a slightly extended, but it's basically just a credit facility to the buyer on slightly different terms. That can certainly be made to work legally, and it seems to be a nice, clear way of doing it. And though I see various different structures in there, I actually quite like that. I think that's a tidy way of doing it. So yes, certainly, because the issue that makes people want to take assignments is usually concern about the insolvency of the supplier if you're having to go through the supplier to recover. Because that is the crucial situation. If your supplier is insolvent, then you want an actual assignment that enables you to bypass the supplier rather than have to ask the supplier to go and recover. But of course, the whole point of supply chain financing is you bypass the supplier because you've got the buyer, you've got their debtor in a direct contractual relationship. So that's certainly worth thinking about.
Celia, thank you.
Pleasure. Thank you.
I'm pleased to welcome Ron Van Statten, who is in-house legal counsel at ING Bank, and Jeff Wynn, who heads up the trade finance practice at Sullivan & Worcester. Given that I think it's around 6 months since the new BAFT agreement was launched, I think first of all, Jeff, if you wouldn't mind, having been probably the most intimately involved person in the production of the new agreement, could you just, for the benefit of the audience and for some of you who may not be familiar, what was the reasoning behind updating the BAFT? And during that process, what were the kind of main topics and themes that were focused on?
Yeah. Can I, just before I start, apologise? One of my clients double booked me, so I'm going to have to leave here at 5:30, pretty smartish. So
no problem.
I'll try and come back. Just leave a drink for me at the bar.
Will do.
Okay. If you think back, the old BAFT, the original BAFT was put together in 2008. It's quite an interesting long time ago. And what was clear was that it was looking a little bit tired. Post the English law BAFT, there was a New York law BAFT, which came a couple of years later. That, if you ask the New York parties, made some improvements, and I'll come back to one of its improvements. And as a result of that, I think you, as the practitioners in this market, through ITFA in particular, started pressurising BAFT, whose document it is, to look at updating BAFT. And that updating process started about 2 and a bit years ago, and it was actually quite a long process, trying to work out what should be changed and what shouldn't be changed. But the key driving force was going back to the New York law BAFT and remembering these wonderful terms. The English law BAFT treated the relationship between the grantor of the participation and the participant as a debtor-creditor. In other words, when the participant contracted with the grantor and put money up in a funded participation, or when called upon in an unfunded participation to put money up because there was a demand, its relationship was a creditor, which meant that in reality there was a double credit risk that the participant was taking, not just on the grantor, which it hadn't really thought about, but also on the underlying obligor, which it was prepared to take. And lots of questions came up because 2008 saw Lehman's, the issues about potential bank crashes, and the US, approaching that differently, said, we're not going to have debtor-creditor, we're going to have a true sale. This meets what the auditors want, and what we're going to say is that the grantor, which in New York terms became the seller, sells to the participant an undivided interest in the underlying transaction. The challenge that ITFA and then BAFT through to lawyers, on which we decided to grab the nettle, was, can we, as a matter of English law, create the same arrangement under which the seller, as we will now call him, not the grantor, grants that interest to the participant, and consequently the participant's rights to the underlying transaction that it has bought into would survive, notwithstanding the bankruptcy of the seller. So that drove the first change. Whilst there was a discussion going on, well, what should we change? You get to some interesting questions. If you remember the document that many of you still work with, it had an optionality. There were about 3 places in the document that had options. If you want this, you can use this bit. If you don't want this, you can use another bit. Ignore this clause, not have this clause. If I'm being cynical, and I'm being I suppose, taped about this, so my cynicism will be recorded. A lot of banks took the opportunity of saying, well, hey, look, if these clauses are optional, perhaps the whole approach to this can be optional. And what I think you had is the large banks in particular said, well, actually, this is my BAFT. And so if you looked across the market, you had quite a lot of variations from the BAFT. So you could no longer say, hey, there's a BAFT document. You had a BAFT variation. And I know the Ron's Bank probably did much the same thing. So the question then is, if you're going to bring the document up to date, and you're going to deal with, as we've read, the true sale, what would you then do? We dealt with the transfer of an undivided interest using an English concept of equitable assignment, i.e. a non-notified transfer, but then built on that in what is clause 6 of the new document. We also dealt with one of the difficult issues, which was that if there was a disagreement and certain other circumstances whereby the participant said, actually, I've had enough, I want to appear directly to the underlying obligor. And we introduced a concept called elevation, under which the participant could be given direct rights, legal rights against the underlying obligors. We also took the opportunity, bravely, of removing any optionality. So we, with the drafting committee, took a view about which option one might have in each of the optional clauses. So the new BAFT has no optionality. We also took a very brave view and we removed that fraud clause that had two options that you lot all love to debate at various times as to, do you have option A or option B, who takes the risk? And we said, are you sure that you really need that? And we're sure you don't need it. As a result of which, you can debate that in a minute, as a result of which, there is no fraud clause, but we have beefed up the responsibility that the seller has when he sells the transaction. We've given better rights to the participant. There are some representations and warranties that the seller gives by way of comfort to the participant. We have dealt separately with the treatment of principal and interest or income payment to allow you to play around as you have lots of imagination, so that you can actually offer a transaction where you give 50% to the participant, but not necessarily 50% of the income. You can skip, in other words. So there's a concept of income payments and allows you, in the offer and acceptance, to deal with it. We've supported what we've done, now it's been agreed, with an Article 194 opinion, which says that this works as a credit risk mitigant. And the final words I will give to you before we debate it, because we could have done a lot more in that document. The idea was that it should be evolution and not revolution. So why didn't we write clause X? If you want to complain about it, the answer was we changed what had to be changed, which is the classic bit of Latin, mutatis mutandis, changing what had to be changed. That's all we did.
Thanks, Jeff. The evolution, not revolution. Ron, if I can turn to you, at your bank, what's your views on the document? Are you using it? Do you foresee any issues with it?
So we like the documents. We've been working together on the same working group to get to this result. So I think this document, compared to the previous one, is an improvement on many aspects. So therefore we like it. The only thing is we have, of course, many master participation agreements already in place with a lot of our banks. Now, to go back and start that whole process again with a new one is going to take some time, and convincing also my front office colleagues. They will need to spend time reaching out to their other banks, and they will have to go through this whole process, which has been an ongoing process to start with. Those of you that work for a bank probably recognize that it can be time consuming, even though we are working with a master, because inevitably banks will have their own preferences. This is also the reason, as Jeff pointed out, why they've taken out so much of the optionality. But even then, banks will still have issues on certain points, very strong views perhaps on sanctions, whether they should be in or out, on fraud, and maybe a few other points, on tax issues perhaps. So that process will continue. And I think, to answer your question, I think eventually this will be absorbed by the market, but it will need its time. And a year or less than a year is way too short to judge the success of the document. I think we need much longer to be able. But I think that the direction of travel with this from the previous document to this one is a good one, and I think it's an improvement. There's one point I wanted to add on the point that Jeff has mentioned about this new version, giving the participant some proprietary interest in the underlying asset, as used to be the case in the New York style participation agreements. I think from a participant's point of view, you can only see that as an improvement, right? I mean, so the default on the underlying obligor, and then a default risk on the selling bank. If you can get rid of that second risk, that's an improvement from the participant's point of view. I think that might not be the only reason why some parties have pushed for this change. I think under some of the accountancy rules, and I'm thinking particularly about the US GAAP rules, there's probably a necessity to have done it this way. In some cases, I think for certain selling banks to get this asset up to the participation percentage of their book, or reduce the risk on it, they need the other side to be able to partially put it on their book. And that can only happen if that other side has some proprietary interest. I think that might also have been a motive underlying all this. The other point I wanted to make on the document is that the feature of having a proprietary interest through I think we called it an equitable assignment, that is granted to the participant, might have tax implications. And so as a participant, you would want to look at that. And even as a selling bank, you might want to look at that. Because if your borrower is asking, who is the beneficiary of the interest that I'm paying, and you do get borrowers that are sort of required by their tax authorities to send out these things, having an assignment compared to not giving an assignment to your participation, to your participant, might make a difference from a tax point of view. So that's another point to take into account. And you might want, if you work for a bank and you want to use this document, let your tax people have a look at it as well.
Thank you, Ron. We should just mention, depending on whether your institution favours the English law or the New York law. It's the English law that was launched last year. The New York law is still to be to be launched, isn't it, Jeff? Is there a time scale?
Almost ready to go. If people would stop commenting, it would be ready to go.
So
the guillotine was the beginning of this week. But people are still putting comments in.
So if you're more interested in New York law, pretty soon that should be
the New York law looks very much like the English law. The idea, BAF's idea, which we then implemented, was to make the two BAFs look pretty much the same, other than by the change of law, and only any things that were absolutely required by New York law. There. So if you do a compare eventually, those two documents are going to look almost exactly the same.
Okay.
That's right.
Interested to hear from the audience. Other institutions out there with a view on the new document? Are you adopting it? Do you have any issues? Are you waiting and seeing? Anyone got any views to give there?
I'm happy to comment, Carl.
Sure, Dolly. Yeah, go ahead.
Obviously, we're on the buy side, so as a buying entity or the tech asset participant, I would say the non-optionality to the fraud risk for us is a problem, because for us it's important that the selling banks take the fraud risk. And my question is, which I want to just ensure is possible within the offer and acceptance wording to include the fraud to be the responsibility of the selling bank or not?
Oh, the answer is yes. That you have a master document, and on a transaction by transaction, you still implement your transaction with an offer and acceptance. Therefore, in theory, you could, if you were concerned, put that provision in. I would still suggest to you that even if you looked at the old BAFT, how that risk of fraud was dealt with was not clear on either option. One option said it will be shared, the other option sort of indicated in very narrow terms that it was a risk of what was then the grantor. We think that if, as a participant, when you buy a transaction, if you look at the responsibilities that are still given to the seller, particularly in relation to documentation, there's still that clause there, that I would hope you may well conclude you don't need anything more.
Yes and no. So I think if there is an argument between a buying entity and a selling bank, and everyone thinks they're right, you will find that you have to go through an investigative process for the selling bank to acknowledge there was some discrepancy in documentation. I don't think a bank will happily acknowledge that actually check documents properly, and there's a risk of
And there'll be a DocDex determination.
Yeah.
What I'm saying is that will apply. The idea of saying, oh, well, I don't have to worry about that because I've got the fraud clause, is I think is a false belief that as participant you are, quote, fraud protected, unquote. And that's why we suggested it be taken out, and that's what the working group felt was the right thing to do.
Yeah.
I mean, I know, I've been around for a little while, but I don't know anybody who's actually ever implemented a claim as participant against grantor in respect using the fraud clause.
I would like to add something else. When it comes to document checking, I think that's, as it's currently drafted, still with the selling bank.
Correct. Yeah.
So that doesn't change. When it comes to fraud, what I can say in addition to what Jeff has just said, I mean, some banks take this view on fraud as being an issue which can be assessed by the banks that is selling the transaction to a participant. And therefore, as it's able to assess that, it should, if it makes a mistake in the assessment, it should bear that risk itself, and it shouldn't be shared with the participant. Having been on both sides of this, buying or selling, I don't share that view personally. I think when it comes to fraud, it isn't something that a selling bank would be able to assess. The parties you're dealing with are parties you usually know. If fraud happens, it is probably even a surprise to that party itself because it's an isolated problem of a few people. It's hardly ever structural. And if it is, then you can argue that their KYC processes haven't been properly complied with. I think fraud normally manifests itself as a few individuals that have set up a scheme, and there's no obligor, which is a client of a bank, normally in the business of committing fraud. So it's very hard for a selling bank to assess that risk. If it happens, it's just one of those things that happen. It's part of the risk. If you're selling the risk to another bank, then that's, I would say, a risk that has to be shared. With one caveat, that if you've made a mistake in selecting your perhaps your client, you haven't done your checks properly, or you could have seen and spotted a fraud and you let it go because you didn't have any procedures in place to do any checks, then I think the document as it is allows a participant to say, oh, hold on a minute, you're asking me to pay now? And then you can have a conversation about the mistakes the selling bank might have made in that. But generally, I don't think you can say, as a rule, fraud risk, it's with the selling bank and it cannot be shared. I think it's a more balanced view if you start from the point of view that it's normally shared.
I could answer to that, but not
No, okay.
So I guess the danger of that is that those that are used to the older version where they felt there was that cover of fraud will continue to use that document. We've spoken with a number of banks over the course of the last few months to build up with buyers to build up our asset book, and I haven't seen many that have turned around and said we will be using the new BAFT. They are reviewing it, but there hasn't been any. There's some, but a large majority of them haven't adopted it, and it sounds like it's not going to be the case for a number of months, let alone potentially years. And for us, having that safety, even if it may be argued in court of the grantor would take on the risk of fraud, is a comfort that we're keen to have.
But you know, many banks, particularly on the seller side, wouldn't accept that point anyway. New York BAF didn't have the optionality. It just took a straight view that the fraud risk should be shared. So to that extent, if you like, the English BAF with its optionality, although some people managed to put both in, which will cause great confusion. You were supposed to make a decision. But, I mean, when we debated it, the room, it's a bit like Brexit, the room just divides as to those who think it should be seller risk and those who think the risk should be shared.
And maybe depends also on the underlying transaction. I mean, if you look at the receivable finance, so everyone is comfortable with the risk underlying because you know the corporates. But if you then purchase a letter of credit and you don't know the exporter, the supplier, then of course you would rely on the seller.
But you can, I mean, if you took that as an example, one, there's a fair bit that pushes the responsibility onto the seller still, the clause that says he's got to check the documents. You've got representations anyway, and if you really are bothered on a particular transaction, you can add something in the offer and acceptance. And we just felt that the fraud clause was just an unnecessary diversion as to what you really ought to be doing.
I mean, having said that, if you deal with the correspondent banks, I still think never came across a fraud risk in my 25 life now. So this is, and we had many discussions on the fraud clause. That I personally also would say, just leave it like
I mean,
that.
look, on a show of hands around the room, if we can do that. I mean, who in the old BAF terms, who thinks that the grantor should take fraud risk? None of you. Who thinks the fraud risk should be shared? Don't be afraid.
Yeah.
As I said, it depends.
Well, that's the answer. So, well, is that 50% of the room said the fraud risk should be shared? So that actually demonstrates part of what I was saying. Is that if the fraud risk is shared, then it's just a diversion as to. But actually, when I said fraud risk should be shared, I still meant that the seller should take documentary risk. And he took your eye off the fraud clause and put it onto the document clause. That's what it was about.
But the divide is the buyer and the seller, though. The seller would prefer to have shared compared to taking full risk, generally.
Well, some sellers said, actually, no, I do take documentary risk. Indeed, they still take documentary risk. But fraud is, I love it because it gets the room talking about it. But in reality, it's just a rather funny diversion into a lot of things that are much more important.
exactly. I mean, I converted my opinion. I was, as you know, Jeff, an extremely hard defender of the fraud clause, and I am only a buyer of assets. I don't sell any assets. And I must say now, I am fully fine now that there is no more fraud clause, because indeed I have also in all the many years, I have never been using this fraud clause, and as Irene says, it's always a long debate for nothing really.
Well
And it's much better if you, like that, pay attention and really go and look into the risks, and if there is anything you cannot accept, you put it in the offer acceptance, and then you are aware, you really do your underwriting very carefully. Otherwise, you might neglect that point, thinking, oh, I have some cover, which in the end maybe you don't have, because it was also, it would be very difficult to implement, to prove that there is a fraud. When is there the fraud? Does there have to be a court judgment that there is a fraud, or what? It was never really clear.
I'll try and move it away from fraud, but just to pick up on the tax point.
Yes.
Yeah, that was interesting in terms of, Obligor was saying, who am I paying, etc., etc.
Yes. Yeah.
Right? But if you've got an undisclosed participation,
Yeah.
is the seller obliged to actually tell them, or
That could be a tricky one. Some jurisdictions and the tax authorities speak to their resident borrowers and say, you say to me that there's a tax treaty with your lender, that you, as a result of which you're not withholding any tax. Can you confirm that that interest is indeed going to that lender, and that there isn't some fronting scheme, and that there's someone else behind it? Not every tax authority that deals with these kind of treaties to avoid double taxation or to avoid withholding tax are sort of as diligent or as on the ball as others are. So there's a great variety in what we hear from our borrowers. But we have seen, and it seems to be on the increase, borrowers asking for this. And we sort of looked at this, and we have to look at the law, the tax law in that country. And so what does it mean? Is it form over substance? Is it substance over form? If it's the latter, then having to pay, part of your income onto the to the participant, if it's drafted in a way that is usually done, which says you're not paying part of the income, period, you're paying an amount equal to a percentage of the interest that you receive. There's a slight nuance in it, which is great for lawyers, and hopefully it works from a tax perspective, but we don't really know. What I do know is generally that if you have that setup, and where there's no assignment, and then you have a setup where the participant actually has a proprietary interest, you cannot really say, or it'd be really difficult to say that that participant isn't the beneficiary of that interest anymore, if you know what I mean. It becomes a different assessment. And I'm not saying that, therefore it becomes a problem. I think it depends on the jurisdiction, the borrower, your wording, and then the tax treaty that is at stake between the two countries.
Which
And
is why the document didn't even attempt to deal with that. It's why in the guidance notes that are with the document, it says you need to look at the underlying transaction. You need to make sure that you can, in fact, grant that participation. Sell that undivided interest. That was the point. That was the warning. Most of the time, you'll be okay. But as Ron said, if you were doing the transaction in the knowledge that there were difficult tax issues, and those of us who remember fronting banks and remember the past and all that, if you know that there's a potentially difficult tax issue, then you would want to point that out to the participant, and you may want to do something different in the offer and acceptance. Remember, you've got a master, but you can deal specifically with a transactional issue in your offer and acceptance. And that's the best guidance.
But as it stands, if you had a seller and a participant, as it stands, it's the seller's responsibility to understand the tax implication, or is it the participants, or is it both?
It's both. It's both.
There was a discussion in the working group on the tax rep to be given by the seller. There is no tax rep by the seller. What I mean by that is the seller is not giving a representation of warranty that there's not going to be any withholding tax, because they see that as, it was seen as, you know, the participant can do that assessment itself.
But equally, if you're selling a participation and you're saying, and you'll get this and this, in other words, you'll get this amount of this percentage of principal, and this is the income payment that you'll get, and you've got that wrong, because that's not what you're giving, then there will be a claim the participant has. But you do get into, you know, the potential argument, you know, because the seller does not have to gross up.
Exactly.
The participant has to gross up. He has to make sure that his payment is
he'll get less.
But on that way, he would get less. So it's for him to ask if he wants. Remember, it's still buyer beware, it's still buying.
Yeah. And on the disclosure point, that when we do get borrowers that ask for this statement, who's the beneficial owner of the interest that you get paid, it could be tricky. Depending on the arrangements that you have with a participant, it could be tricky it could be difficult to avoid having to come to some sort of disclosure. There's no one answer to this, but it's certainly a point that we've looked at and had to deal with on a few occasions.
But law obviously overrules breach of the agreement. You know, if by law you have to disclose, are you then in breach of the agreement between participant and?
Potentially, it could be that if you have a legal obligation, but contractually you've done something else, the fact that you have a legal obligation doesn't necessarily, you know, make your contractual obligation disappear. It can, well, if you draft it that way, then of course you could do that. But if it's not drafted that way, you can be put in a tight spot. Yeah.
Yeah. Okay. Moving on, the old BAFT, whilst theoretically it catered for all types of trade products, was very much kind of concentrated on traditional documentary trade. The new BAFT is more open and especially around the idea of open account receivables. But nevertheless, there are banks out there that are producing their own product-specific MRPAs for receivables. There's the surety agreement as well that some banks are using. I think one is under discussion with ITFA, isn't it? So how do we see, you know, new BAFT, is that going to be, do you think it'll need to coexist with these product-specific?
So we've got banks who are looking at their master participation and saying, I want to migrate to this one, tell me what the difference between the two is, and I will now want to use that. We are also having clients who are saying, we want to grant participations in a wider sense, and they are, if they come to us, are being persuaded to structure it based on the new BAFT. So when ITFA's insurance group looked at the surety master participation is based on BAFT, the new BAFT. We're doing some pooled participations. It's going to be based on the new BAFT. Because why would you not? Because a lot of thinking went into the new BAFT. You know, there's a receivables option sitting out in a schedule, which enables you to be very specific if you're using your BAFT for receivables. So you would bring in that clause. You might, because of what you're doing, because it's more special, you might build on that. But I don't think that there's any reason to say, oh, I can't be bothered with that, I'll create a brand new template. Because we would hope that this is a good template for participations between a seller and a participant. You can apply it to all sorts of things. I hope. 2 minutes.
I'm conscious of time.
Yeah, it's all right. I'm interested.
Jeff, do you think the additional on the residual finance language in the new BAF, I think there's one clause you can add.
Yeah.
Is this sufficient to cater it? Or, because if I look at different residual finance agreements, they look much more different than the BAF MRPA.
Can you grant participations in a receivable transaction using BAF with that clause? Yes. Now, the thing is, again, because you lot are quite inventive, if you want to grant things in a different way, because part of the problem is what do you want to deal with, excluded risks, whatever you want to call it, then no, because the concept of the standard participation is I just grant you a participation in the transaction. I sell you an undivided interest. If you want to say, I sell you an undivided interest, but actually I'm prepared to take risk A, risk B, risk C, we can write that. We can write it in the offer and acceptance on that. But it's not. The sophistication is, this is for the market. This is the consumer generally. You want to tailor something. Yeah, I mean, in fact, we're doing one at the moment that sadly is now so bespoke that it sort of pays lip service to BAFT. If you like, it was one of these from an original idea by BAFT. I'm disappointed, but it's not between two banks. And so the parties are crafting. But actually, if you look at it and you look at the clause order, you would say, that's a passing resemblance to the new BAFT. But it was better than a blank sheet of paper. But lawyers don't like blank sheets of paper, you realise that.
Jeff, there's a new in the new document, is there, you touched on it, did you look at the ability to step around, the participant to step around the fronting bank?
Yeah.
We now have day one elevation, but we had it before where default, disagreement on enforcement, then you would elevate, but you're still got an equitable assignment of a part, and you could give notice of assignment as much as you like to the debtor. They don't have to deal with you. But did you say you dealt
elevation
the step around rights or consultation rights?
Yeah. It's the consultation is a bit tighter, but again, we didn't need to change because I think most people were fairly happy. The right to say, I want to be the direct party, which we've called elevation, is there in various circumstances whereby the participant can call for that right. Or when, of course, the seller gets fed up with the participant, he says, it's yours, this 30%, you go do what you like with it, I'm giving you a direct assignment of that right.
What we didn't do is when there is this discussion between buyer and seller on certain action to be taken in relation to the obligor, if they disagree on that, what we didn't go for was the solution that that there was going to be a cancellation of the participation, or that the only option for the selling bank to come out of that deadlock is to cancel the participation, because that would have a CAR implication which wouldn't work for a selling bank. Yeah.
One point that was mentioned is obviously till we move from the old BAF to the new BAF, there could be months or even years to get to it because there's a lot of work, convincing the parties. What could be an interim solution? Could we have an addendum if we say, look at things in like a year's time and realize that actually people have not moved on to the new BAF? What are the plans?
We weren't paid to do that. And I'd love to do it for payment. No, you. Structurally, you could agree in a particular participation to incorporate by reference the new BAFT as if you had signed it. So you could work your way around it. if you felt, oh, this transaction I really would like it to be done on new BAF terms, but I can't be bothered to negotiate the brand new document. And I suspect as people start thinking about it, just as you've asked, people will come and say, I think we could work around this. We like what's there, but we can't face the problem of having to negotiate or renegotiate a master, but we'll do it. And of course you can do that quite easily because there's no optionality. So you could actually have an offer acceptance, incorporate by reference the new documents if you signed it. You like that?
Yeah, I do like it. I'm aware that you need to go, but I'll just say something. If you want to slope off, that's fine. The other thing is, what always works if there's a deal on the table, actually, buying or selling, and use that as a momentum or the trigger to start, apply the new BAFT or some other document. That's where you get things done. If you try and change from an old master to a new one, when there's nothing, no pressure of a deal being, that my experience is we're all busy.
I'm just conscious that we don't all want to wait a couple of months or years till the new BAFT really gets into the market, because before it was easy. We didn't have one. Everyone had their own standards, so we all switched to BAFT.
Yeah. But look, you can have a new BAFT in 2 hours. Just decide who your master party is, decide who your counterparty's master party is, and you're signed, and you can use it for any subsidiary in the group. It's just, there's got to be the mindset. I mean, I'm going to leave you all to, you'll excuse me, but you can debate the different ways you might do it. So if I can get back, I will, but otherwise, my apologies.
Thank you, James. Personally, I think you're looking at a lengthy period in which we transition from old to new. You touched on it earlier, didn't you, Ronnie? A lot of the big institutions, they've got hundreds of these agreements on their files. So, yes, of course, there's always opportunities, a transaction opportunity. I guess, okay, should we do the new BAFT or not? And of course, the new BAFT doesn't have that optionality. So I think the good thing will be there are less excuses with the new BAFT that you want to deviate from the standard or in some way. Having said that, we know what big banks are like. They always like to tweak in to suit their own style, don't they?
That's why we may consider something for the interim, so that we've already discussed it, but obviously want to see what's going to happen in the next 6 months and the next year, and then maybe take a decision at that point as to whether we want to do something as ITFA to have something in that interim framework.
I just think having to agree the interim solution, is that going to be quicker than just trying straight to the master? If there's a willingness on both sides, who knows, you might get there quickly. The problem is, the sheer number of MPAs that banks have agreed. So where do you start? And I think that's going to be a practical issue.
For sure, it's just because there are specific clauses which we all look at in the new BAFT, which we know are better than the other ones. So maybe that's what would make it easier. I mean, it's just something we need to talk about in like a few months, basically, to see if that's something we can.
The ultimate test is the market functioning. Are sellers able to sell risk to buyers using what will, I'm sure, continue to be our main means of transacting in the secondary market. If the market starts to seize up or there's delays, people not happy with, between two agreements or things are just not going to get done, then that surely must force some action. But I guess we need to see.
Has anyone, either on the buying or selling side, been asked to deal and to agree a master on a new BAFT template?
Yes.
On the buying and selling side, if I may ask?
We've actually got 3 done.
You got a few done, yes. Good.
Who's ready to go with the new BAFT? Who's ready to go, even if you haven't done a transaction? Not too many.
Yeah.
Not too many.
There's some that we'll look at some. We'll have to go through a review process to see if they can accept it as it is or make some tweaks.
Of course, yeah.
I think ultimately, you're absolutely right, Carl. It's big banks and smaller banks. Smaller banks are more flexible. They can go in.
Yeah.
To be honest with you, as a small bank, it's a great document.
Yeah.
It's easy. We've got it. We've got everyone bought into it.
Yeah.
And if the other bank, your counterparty, is exactly the same, it takes 5 minutes to do it. It's literally 2 signatures on a piece of paper and you're done. So if all the big banks were to say, let's adopt the new BAF, and if that took 6 months, and then everyone just came out and went, we're all signed up, isn't that the actual reason for BAF, is to actually say, get a standardised approach that the whole market can do.
Yeah.
And then, I know, that we're talking a, utopia world there, but that's the ultimate principle behind it, isn't it?
Yes, I think those banks that have in-house counsel at hand that has to put their stamp on it and sign off on it, that will slow things down. If you're a bank that rely on external, you can get it done much quicker and you haven't got the same internal fight and battle on your hands. It's just the reality of being in a bigger bank.
But I think it's absolutely right. You will, once more of the larger institutions use the new document, then it'll get that momentum.
Yeah.
Whilst the many banks are still thinking about it, haven't adapted their templates, and being honest, my own institution isn't ready yet. We need to. We're starting to go through a process of how we adapt our template. So we are a little bit slow there, but then I'm not sure if there's a lot of big banks that are really fighting the calls for the new document. But that has to happen for it to get any momentum in the market.
There another approach that the main issues could be addressed to ITFA and then ITFA address it to Sullivan & Winchester again, because from what I learned from the German market, there are some clauses which they don't understand properly. So this might be then also more education, basically.
And there will be that. There'll be regional, geographical issues, won't there, in certain markets. With this document, could be that as well. But that for me kind of says you're going to go down the road of optionality, but maybe you have to have that.
No, maybe
ultimately,
just
or
clarification. I think also what I hear from the partners I'm talking with, from the business side, they rather want better standards. They don't want to have different clauses, because from the experience now from the past, I think almost no one has a same agreement with another counterpart, so all are different. So the new agreement, which actually really help them to have a standard document, also from monitoring side, there are different aspects. Legal, of course, is different. Legal probably will push to change some clauses. But from the business side, I think they're mainly fine with it.
I mean, there is a guide to the document and to the changes, but for some people, some of the clauses might not be clear, and they might have questions that might slow things down. I don't know if they could be lumped together in a sort of, certain type of question that could then be addressed to the draftsman or women.
I think
maybe jumping on that, what we can do as the ITFA MPC is take these comments, if the regions or members want to forward those comments on to us, then we can address them as a package and then make them available to members, and that will make it easier, hopefully, to address any concerns where people don't quite understand how it can be applied. And then maybe there still needs to be some variations for different cases, in which case, again, our recommendation is try not to mess around with the master and put those into the offer of acceptance, because then, again, you make the execution of the master a lot quicker and easier, and you don't waste time with that. And when you have a specific transaction, you can focus on the offer and acceptance and what needs to go specific to you into that, and there's a deal that motivates people to find that compromise.
And I think a good idea would also be to do regional events like this one here, and maybe bring your lawyers along. I mean, we will have in June the regional event in Germany. We can organize that and recommend to the parties who have issues to bring their lawyers along.
We could do something specific for the lawyers.
Yes.
More events. To the list.
Good. Okay. Any final remarks?
Yeah. One of the things we've identified with the EVA is the aspect of true sales and the actual transfer of title. And actually, would that actually happen or not? As us, as a Spanish bank, we don't believe that title will actually be transferred. If in the case of our insolvency.
Yes. When people use the term true sale, we have to be careful that we don't. Well, we're talking about the same thing. So there's the sort of economic or accountancy sense of a true sale, and there's the legal idea of a true sale. With the legal idea of a true sale, I think you should be thinking of transferring some sort of proprietary interest to another party. It doesn't necessarily mean anything about who's sharing the risk and what risks are being. When an accountant, in looking at the balance sheet, when you're looking at true sale in that context, it could mean something else. You could have a true sale where there's no transfer of title, but the participant, the buyer, takes all the risk up to a percentage. So there's no one definition, and you have to be very careful as to when you use the term. When Jeff used it earlier, it was simply to say that in the new BAFT, the participant gets a proprietary interest in the underlying asset, which is a new thing, because under the old English style BAFT, they didn't have that. It was a debtor-creditor relationship only, and that's now. At least there's an attempt in there that it changed. I mean, whether that works depends on a few things. I mean, this is an English law document. We've got the New York one soon coming out. The English law document says, there's an actable assignment. That might work between those two parties. Whether that's recognized in the insolvency of the selling bank is, again, another point, because if you're a Spanish bank, I mean, what does that mean on the Spanish? Would that be recognized? So it's not the end of it. There's a lot more layers to it. And then you're looking at the underlying asset itself, because that comes back to Celia's earlier presentation. It might not even be assignable. But what does that mean under what law, what governing law, and what does it mean to have a prohibition in there? Can you still get an actable assignment under English law? I mean, I'm throwing way too much questions at you. You've only asked me one, so I'm sorry.
I'm just wondering if
it's hard.
on us to get a legal opinion on that, being a Spanish bank. So, because surely if I'm selling something, I need to know that if I'm saying I'm transferring title, I know I've got to know that I actually do that.
Yes.
Work out what the purpose is of sorry, say
I
that.
was just saying, one of the things that the case I was looking at, there are a lot of different ways of doing it.
Yes.
And that was just to throw that
Yeah,
to throw
yeah.
it in. Sorry.
Yeah, no, that's fine. I mean, and I totally agree. And I think when you ask for an opinion, like a true sale opinion, go a bit deeper and trying to work out what's the purpose of that true sale opinion. Is it to get capital relief? Is it for accountancy reasons? Do you want to have it de-recognized, or do you want to have just a lower risk on your book for your RWA? There's different things and different reasons as to why you need it. So rather than saying, oh, we need to get a true sale opinion, I'd say, well, exactly what's the reason? What do you need it for? De-recognition for a funded participation is one thing. Would a lawyer be able to help you with that? Only up to an extent, because for the other bit, you need the accountant. Is it transfer of legal title? Again, that's another question. The lawyer might be able to help you with that, and you get a different opinion.
Transfer of legal title, you're right, legal true sale is really narrow, and under English law it's really quite easy to get, and all these other points about why you want is absolutely right, accounting true sale or balance sheet treatment. But I think for getting a legal true sale opinion, it's not too difficult on the BAFT, because it's an English law document. As a Spanish bank, you probably need a Spanish opinion just to say that would all.
That's kind of how we.
That English choice of law, the English assignment, the English treatment of work, you've alienated that portion of it, and it would stand up in the Spanish.
Then the other
insolvency.
yes.
But the other element is
Yeah.
the underlying the law of the government, the asset, whether
actual
an
asset
English
itself.
law
Yeah.
assignment will work to convey that portion of that French law loan or receivable. That's a different question. You've got to look at that as well.
If it's a contractual right, then you need to understand the governing law. That is actually what will lead you towards its transferability. So that's.
We'll need three. If you want to do property, three. But if the asset is English law, no problem. Right? English law asset, English law assignment, those match, and then you've just got Spain and England to do.
Okay, I think we ought to wrap it up there. Obviously, lots still to discuss, and yeah, let's see where it goes.
But let's open for the questions. What Paul said. That obviously, if people.
I think that's a good. Yeah. So we can follow up. I think that's a good idea, Paul. Yeah. We should have a chat about that. Okay. Please do feel free to stick around. The bar is open for drinks. Food will be served shortly as well. So you're more than welcome. Please do stick around. Just see if we can move some of the chairs to make some room. But thank you, everybody. Ron, thank you very much.